criminal law prosecution is Aaron McGowan. And Aaron received his undergraduate degree in English and psychology from USC. And also,
good school.
Yeah. And also his law degree from USC as well. He was a deputy state's attorney in Minnehaha County for about 6 years, and then was the managing partner of McGowan and Hensley for a few years, and then went back to the Minnehaha County State's Attorney's Office as the state's attorney, and is now the chief prosecutor. Just also want to introduce Rhett Bai, who's here today observing, and he is a deputy state's attorney. We're happy to have them both here with us, and we'll turn the time over to you.
Great, thank you. I am an old, stuffy prosecutor, so if you didn't get a chance to grab some caffeine on the way in, go get it now, because it's pretty dry stuff. My name is Aaron McGowan. As you know, I'm the elected state's attorney for Minnehaha County. Is there a mic that I should be speaking into, or will it pick me up in this area? Okay. I want to give you just a little bit of an overview of our office before we get into the slides. We have, I guess it'll be 28 prosecutors in our office right now. We have support staff of basically 10 legal office assistants. We have 3 paralegals, 3 investigators. We have 3 victim witness assistants in our office, and we are set up into different divisions. We have a civil division which provides guidance and legal advice to all of our elected and non-elected department heads. We have a juvenile division where we have prosecutors that handle abuse and neglect proceedings. We have prosecutors that handle our juvenile proceedings, and the rest of us handle adult criminal work, anywhere from a speeding ticket up to capital murder cases. I think we had 7 homicides last year. My office probably handles between 1,500 and 2,000 DWIs a single year just out of my office. We handle over 10,500 adult criminal cases per year. On a daily basis, it's very common for our office to handle 200 to 250 adult criminal cases in one single day. It's a very fast-paced, high-volume, somewhat stressful atmosphere, which most days we're just trying to stay above water. The typical caseload for a prosecutor probably is at least 150 cases on their own personal trial calendar. So there's a lot of expectations as far as the volume is concerned, a lot of extra hours by our staff. Like I said, as far as the responsibilities of our office, I want to give you just a little more detail on what we do with those. With our civil division, we have 2 attorneys and 1 paralegal, and they work together. They spend a lot of time advising our county commissioners. With county government, we have 5 independently elected county commissioners. They are not my boss, but they do have control over my budget and my purse strings, so they're kind of my boss in a way, even though I'm independently elected. But we provide guidance to them. We actually staff all the county commission meetings and answer legal questions they have. Because we are such a large county, we have large departments, we have our own jail. I am technically the sheriff's lawyer, and my civil division provides a lot of guidance to the sheriff. We have numerous issues out of our jail, as you can imagine, with jail medical, which is millions of dollars a year. An issue could rise from an inmate that's perhaps drug seeking that doesn't agree with what jail medical is providing as far as their medication. They might want something that's more of a narcotic. They're not getting what they want. We will work on those issues with our medical staff within the jail. We engage in collective bargaining. We engage in wages with the Sheriff's Association. We represent the treasurer, the auditor, the highway department. We work on many different civil issues. So that's a very busy department within the state's attorney's office, separate and distinct from our responsibilities as prosecutors. We also represent the county in civil commitment proceedings. An individual in our county can file an involuntary committal piece of paperwork alleging that a loved one is a danger to themselves or their community, and that person can actually be taken into custody. If they stipulate to that allegation and voluntarily get assistance and medical care, then they will just do that voluntarily. If not, there is a hearing where we will have medical experts review testimony and evidence, and my office represents the county at those hearings on behalf of the petitioner where there's a potential for an involuntary commitment proceeding. We have 2 prosecutors that handle abuse and neglect cases. These are civil filings where if the Department of Social Services and Child Protection finds an abusive home environment, our office can work with them and DSS, and at the discretion of our prosecutors, we can file a petition where there's a potential for termination of parental rights. So we will go through this process where it would be a circuit court judge that would decide whether or not these children need to be permanently removed from this home, thus terminating the parental rights. We have a lot of meth houses. We have a lot of addiction issues. Sometimes our children just live in deplorable conditions, and they are the most vulnerable victims in our society. And we have 2 very seasoned prosecutors that handle those cases on a daily basis. Again, not a criminal prosecution, but a civil proceeding where, where the judge determines whether or not that's a fit home for those children. In my opinion, along with some of our criminal cases involving children and other victims, those are some of the most emotionally draining cases that our prosecutors handle, working with those families, seeing those horrible conditions that some of the children live in our community, working with the Department of Social Services and Child Protection to try to bring those parents into compliance, have them go through a lot of different programming, really a lot of hand-holding. Our goal is not to take children away from parents. Our goal is to reunite families, to raise the home atmosphere to a level that is appropriate for those children. And there's a whole separate set of laws and rules that guide us in those particular cases. Juvenile delinquency proceedings. We handle what are called CHINS cases, child in need of supervision, where a parent says, I can't take it anymore. I'm not in a position where I can properly parent my child because they are out of control. So they involve the court system. We have 2 prosecutors that handle those cases. They also handle juvenile delinquency cases where a child violates the law. It's a different proceeding than our adult criminal system. It's a confidential, closed courtroom. It's not open to the public. There is not a jury trial. It's a court trial for those criminal allegations based on those petitions in juvenile court, where a judge will decide, did that child violate that law and what is the proper disposition. And we're really not looking at a punitive element in the child delinquency arena. We're really looking at the best interest of those children, again, to provide proper resources for them. There has been a real paradigm shift in the adult and juvenile criminal proceedings in recent years in South Dakota. Several years ago, I was part of the governor's work group on Senate Bill 73, which was called the Public Safety Improvement Act, where we were looking as a state to build at least an additional women's prison because of a 30% increase in the population of female inmates on drug-related cases and a lot of other instances where the state was looking to save money, not build a new penitentiary for the women's prison or the men's prison. So they had this work group and they instituted some remarkable legislation that was really looking at probation and parole in the criminal justice system and changing different levels of presumptive probation and different offense levels. So I was part of that group that also started drug courts, veterans courts, and DWI courts. Then just a year or 2 later, they introduced Senate Bill 73, which was a juvenile justice bill that really mirrored Senate Bill 73, which was really looking at this paradigm shift of we're not looking to punish kids. We want to bring resources in, try to hold them accountable, yet provide different resources to keep them out of the system. So I'm also part of a group that has the Juvenile Detention Alternative Initiative, where again, we're trying not to lock up kids because we're mad at them. We only want to lock up our juveniles because we're afraid of them. So we've really seen a shift in how we handle those cases. We don't just throw kids in the joint because they drank or smoked pot or didn't come home on time. We really just want to incarcerate those that are truly a danger to themselves or the community. So we work really hard with our juvenile division on those issues. And then the vast majority of what we do, most of our prosecutors work on our adult criminal cases. Again, it can be anything from the speeding ticket, no insurance, underage consumption, numerous DWIs, numerous domestic assaults, aggravated assaults, burglaries, robberies, sex offenses, child rape cases, kidnapping, human trafficking across the board up to our homicide cases. In the next slide, one of the difficult parts of being a prosecutor, I think, is getting that internal barometer of what is the appropriate thing to do with a case. I think most people view the prosecutor as the guy that's tough on crime. He should always go for the maximum penalty. You see some of the Law and Order shows on TV with all these tough old prosecutors that are always trying to get a maximum sentence on the case, and that's really not what our responsibilities are. Our responsibilities are to be smart on crime, not tough on crime. A lot of times the difficult thing to do is not charge a case. Sometimes it's easy to charge a case. Sometimes the right thing to do is no charge the case. Sometimes the right thing to do is do a deferred prosecution and say, hey, this was a one-time lapse in judgment. I'm going to give you a pass this time, but if there's similar behavior in the future, we can go back and look at charging that case criminally. We have a whole list of tools in our toolbox available to us as prosecutors on what we do with a case. If we do bring forth a criminal complaint and charge them, there are opportunities for those defendants to keep that offense off their permanent record. In South Dakota, we have what's called a suspended imposition of sentence. Does anyone know what that is? Who can tell me? Yeah.
Basically, your conviction will get sealed and it'll be still circulation, but it'll be violate probation.
Perfect. Very, very good. That is kind of a one-time deal in South Dakota where if the court deems fit under certain circumstances, the court will suspend imposition of sentence. The defendant would still enter a guilty plea. The court could still have several different conditions that are similar to a sentence, but the sentence would not actually be imposed at that time. There's kind of a gray area where the court holds on to that case. It says, I'm suspending imposition of this sentence for maybe 2 years, and if you comply with all laws and not violate any state or federal law for that 2-year period, you pay a fine, maybe you serve 10 days in jail. If you successfully complete that probationary period, at the conclusion, the court would seal that and it would be as if that crime never occurred. So there would not be something on your permanent record. It would not be something generally that you would have to report to an employer. I was a defense attorney for several years. Oftentimes I would get a suspended imposition of sentence for my clients, and the most common would be a first offense DWI, where somebody has something going on in their life, have a horrible lapse in judgment, have a professional career that could have a lifelong career without a single criminal offense, and that's an opportunity for them to keep that off their permanent record, continue being successful in society. And on a DWI, it has another benefit. Because you're not technically sentenced on that crime, you don't lose your driver's license for the mandatory revocation period. So there's an added benefit there as well. And that's something we see very common in criminal law, where somebody takes advantage of that ability for that one-time lapse in judgment. Sometimes the right thing for the prosecutor to do is seek the maximum sentence. We have some horrible child rape cases and kidnappings and sexual assaults and brutal, evil crimes in our community. I've obtained and been part of prosecutions for life sentences on child rape and kidnapping cases, several life sentences on homicide and murder cases. One, Rhett and I tried a capital murder case together where the jury ultimately voted for a verdict of death in that case. So we really have a broad spectrum of different types of offenses and things that are available as prosecutors in our capacity to seek justice and try to find the just result for that case. And you really just have to follow your gut and your heart. And I think that's the hardest part of being a prosecutor, is getting that internal barometer of, what do I ask for in this case? Do I ask for 5 years? Do I ask for 10 years? Do I ask for 20 years? Do I cut them a break? Do I say probation's good enough? We're going to get you some treatment and some programming. What do I look at in this case, and how do I make that ultimate determination? And there's a lot of discretion in doing that, and a lot of power. But you can't abuse that power. You have to follow your heart and do it, and your gut is the right thing. You will make mistakes. None of us are perfect. But as long as you follow your heart and your gut to seek justice in that case, hold the offender accountable, make your victims whole to the best of your ability, you're doing your job. Questions so far? And I want it to be more of a discussion. I'd rather have you guys talk as much as me. Otherwise, I start to sound like a boring. Yeah.
So when you say that the hardest part is to develop that internal barometer, can you give maybe some examples of kind of how you've seen that develop in your career?
Sure. And we're really blessed in my office to have so many great prosecutors. When I started in September of 1999, I was a 25-year-old kid out of law school. I didn't know what a class 1 misdemeanor was. I didn't know what a class 2 misdemeanor was, and I got thrown in. We had, and still do have, tremendous prosecutors with years and years, decades of experience. I think collectively we have over 250 years of jury trial experience in my office right now. What I would do is just go to all the prosecutors that I looked up to and say, what do you do in this case? What do you do in this case? I would kind of plagiarize and steal their ideas. I would steal their voir dire. I would steal what they do in jury trials, but they were the people that were my go-to prosecutors to kind of engage and develop that internal balance on what I thought was an appropriate disposition on that case. And I think that's the hardest part. We can all go to Title 22 and learn the entire criminal code. We can all turn to Title 32 and learn the entire motor vehicle code. You can memorize and be strong on rules of evidence and suppression issues and all of those things. But having that confidence to go into that plea negotiation and say, hey, it's going to be 10 years or it's going to be 5 years, or I'm going to give this guy a break. I think he or she deserves it under these circumstances. It takes a lot of time, but the best way for me to develop those skills were just to take everybody else's temperature and kind of gauge what they were doing. It's important for us to be consistent as prosecutors because we have to be fair to everybody, but you also have to look at all the unique facts and circumstances surrounding the case, as well as your defendant, because there's a lot of extrinsic factors that may have led that person to that courtroom on that day, and some of those things were out of their control more than likely. So you have to look at the person and all of the circumstances to try to gauge to see what's appropriate in that case. Great question. Anything else before we move on? Deciding who is a victim and who is a defendant. It's not always as easy as you might think in a case. We just recently had a homicide case that ended in an acquittal where there was a shooting in downtown Sioux Falls. The defendant shot at a vehicle that had been involved with the chase. There were weapons and a gun in the decedent's vehicle. The defendant shot at the vehicle, I think 3 or 4 times, hit the grill and the hood. One shot went through the windshield and hit an acquaintance or friend of his in the head and killed him. His own child was at the back seat of that vehicle, and the child's mother was in the front passenger seat of that vehicle. That case went to a jury trial on murder and manslaughter charges. The jury felt that that was a justified homicide in that case because of the circumstances surrounding the victim and the chase and everything that led up to that shooting. As a prosecutor, I never condone shooting in our streets and vigilante justice, and didn't completely agree with that verdict in the case, but I also knew a lot more about the case and the defendant than that jury did. Who knows what 404B evidence is? Yes?
Past history or
other acts, yes. And in that particular case, we had other acts evidence that we felt would be properly introduced. Our defendant in that case was a 17-year-old, so we had a transfer hearing, a reverse transfer hearing, to keep him into adult court to face the murder and manslaughter charges. His defense attorney wanted to move the case back down to juvenile court. Part of that transfer hearing, the court was able to consider the other acts evidence in the defendant's prior criminal history, including he pistol whipped another individual and shot that other individual in the face about 1.5 years before this shooting. but the judge, in weighing that other acts evidence, felt that that was overly prejudicial, certainly relevant in this case, but didn't feel that the defendant would get a fair shake, so that, a lot of that evidence didn't come in. I suspect if our jury knew that our shooter in that case had pistol whipped and shot somebody a year and a half before, they would have looked at the evidence differently as far as being a justified homicide. But those are things you have to look at, decide who's your victim, who's your defendant in the case. It's not always clear cut. We've had a lot of drug rip-offs and shootings in Sioux Falls where the person that ultimately was shot or injured is involved in illicit drug dealing for profit and had hundreds of thousands of dollars and lots, massive amounts of drugs, and they're pushing those poisons in our streets. A lot of times those are people that end up getting shot or getting ripped off in a dangerous situation. So you really have to work closely with your law enforcement. You want to look at all of the facts and circumstances to see who you charge, if anyone, and what you charge them with. But it's not always as clear-cut as we might think. Also, deciding on charges based on the nature and the conduct and other facts and circumstances in the case. Vehicular homicide cases, I think, are a little bit troubling. Who thinks if you're drunk and you drive negligently and kill somebody, you should always get the same sentence? It's a pretty serious crime. You ended a human life. Do you think you should always get a maximum sentence, or does it depend? Who thinks it kind of depends? Okay. What factors do you think might?
Well, whether, I don't know, just from a personal sense, whether or not I know the victim. To me, that isn't really justice if someone gets probation after, I think the actual entity killed 4 people when driving drunk. That doesn't seem right to me.
Offensive to me. And I think there are a lot of different cases. I think you do have to look at the unique facts and circumstances on, how are you going to prosecute this vehicular homicide case versus this one? I had one where we had a couple on a motorcycle, a husband, wife. The husband was just over the legal limit, missed a turn, went off the road, and his wife died in that accident. It wasn't an obscene amount of alcohol. It was above the presumptive level. But we had a dead human being, which is always a very serious offense. But you look at the conduct there versus other vehicular homicides we've had where somebody's going down the wrong way on the interstate at a 2-4 blood test with drugs and alcohol, and it's their third offense, and they hurt somebody, a complete stranger, kill a family of 4, or kill a family on their way to church. I think it does kind of change how you prosecute the case. Does it change how you look at that case if you've got somebody that willingly got into a vehicle with a spouse or loved one versus somebody that goes the wrong way down the interstate and kills a family of 4 that they've never met before, that were just innocently on the street? I think they are different types of cases, and I think you have to look at all the unique circumstances and how you view that case. Cases can also, yeah.
Is there some triggering conduct that you look at when you're trying to decide whether to charge them as a juvenile or as an adult?
Great question. And I think if we go to the next slide here, why don't we hit on that real quick. If you look at the bottom of that slide on the 2611 3.1, that is a statute where it sets out the criteria for charging juveniles. If we do a direct file and it's a class 2 felony going up to a class A felony, so you look at like a first degree robbery or kidnapping or first degree burglary up to premeditated murder, we can take those cases directly into adult court for those specific offenses. The juvenile could have a transfer hearing to bring that case back into juvenile court. We can have offenses lower than a class 2 felony where we make a motion to bring them into adult court where there's not a presumption that they're going to stay in adult court. So we look at a lot of those unique factors in determining where we want to prosecute that case. We've had robbery cases where we had different people that are accessories and play a significant role in it, but immediately went to law enforcement, immediately cooperated, maybe were with the wrong crowd at the wrong time. We have other juveniles that are hardened criminals that even at the age of 17 have a 2-page juvenile rap sheet, and we've exhausted everything possible under the system to try to bring them into compliance. The court, in looking at those, there's a list of 7 different criteria the court looks at. Is it a property crime? Is it a crime against a person? Are there, is there any ability to rehabilitate that child at that age? Is there anything left in the Department of Corrections that we can help that child and rehabilitate them? The court looks at all of those different criteria in making those decisions. We as prosecutors make the same decisions and evaluate those criteria to decide where we feel that case is most properly prosecuted. Other questions on that? I want to touch a little bit on mandatory minimums. And I, as a prosecutor and defense attorney, have oftentimes been in favor of them and oftentimes been opposed to them, and I'm not sure where I always end up, and I think for a lot of different reasons. Mandatory minimums can be very good for the prosecutor in different circumstances, but they can also hurt you. If you've got a case where you want a conviction for that offense, but the mandatory minimum is perhaps too severe for that defendant, then you have to deviate to a different charge. You may have a defendant that wants to plead guilty to the charge, but because of the mandatory minimum, they're going to take their chances at trial, and you're going to end up trying more cases because there isn't that discretion to deviate downwards with a sentence that might be appropriate in those cases. When I was a defense attorney, I had a young man, I think he was 19, that was in a car with 8 other people. He was a passenger. They got pulled over by Chamberlain, South Dakota. There was over 10 pounds of meth in this van that got stopped by a highway patrol trooper. In the federal world, they have lots of mandatory minimums, especially on different drug cases and drug distribution. My kid was not playing a huge role in that case, but because he was in joint possession of the drugs in that vehicle, had knowledge that they'd driven to California to pick up something, and he was going to get a couple $100 for making the trip. Under the federal rules, he was going to do a mandatory minimum, I think, of, it was 5 or 10 years. I think it was 10 years federal time for the amount of weight in that car. I suspect those drugs came from Mexico and were probably tied to somebody that's pretty dangerous. In the federal system, you can get below a mandatory minimum with what's called a Rule 35. If you cooperate with the government, do a complete clear out with the DEA agent or the FBI agent, the prosecutor makes a Rule 35 motion to the federal judge, and the judge has the ability to cut below that mandatory minimum. Generally, what we were getting in those cases was about 50% the mandatory minimum. Because of my young man's fear of the people in that chain related to the 10 pounds of meth in that vehicle, he would not do a Rule 35. I had nothing available to me as his defense attorney to get him anything under the mandatory minimum. So this young kid who's maybe getting a couple $100 for being a mule in a car and get a free ride to California ends up doing a 10-year number in federal prison. That's a case where I think it's not appropriate. I felt that maybe we could have gotten something else worked out with the prosecutor's discretion, but that didn't happen. So I look at it at both sides. We've had cases where we got a real light sentence on a homicide or a crime against a child that I didn't believe it was justice, that I felt the mandatory minimum may have been appropriate or helpful for us in those cases. So they do exist in our code. We have it for drug distribution under the 2242-2, generally a 1-year mandatory minimum for drug distribution, not possession. School zones, there's a consecutive mandatory minimum. Firearm offenses, if you commit a felony armed with a firearm, you generally would get a 5-year consecutive mandatory minimum, and that's a Class 2 felony, so up to 25 years on that offense. You have to be careful in charging the commission of a felony with a weapon, though. With a firearm, a lot of times those elements will merge. So if I commit aggravated assault on my friend right by, if I pull up my 9mm on him and the prosecutor charges me with aggravated assault under the 22-18.1 sub 5 physical menace with a deadly weapon, I can't charge the commission of a felony with a firearm because there's already a firearm element to that crime. So there's other felonies that you can use that with, but you have to be careful that use of a firearm isn't one of the main elements already in those charges. Questions? Moving on to charging decisions, and they're never easy in the high-profile cases, the cases where you've got loss of human life. There's nothing you can do to bring a victim whole in a homicide case. A lot of times you have many members of the family that have a completely different idea of what justice might be in that case. It's a rarity that they all agree is a proper disposition. We had a recent case on a murder rape that went to a jury trial. The jury ultimately convicted of rape and murder. That was a case where we had a family that there was nothing we could do as a prosecutor's office to appease that family. They wanted me to seek the death penalty in that particular case. I had concerns as a prosecutor that it was not an appropriate case for the death penalty. I shared that news personally with the family as to why I was not seeking the death penalty. This was a very difficult case. We had a defendant with a very significant prior history with prior sexual assaults and violence that had only been out of prison, I think, for 7 years of his entire adult life, who probably should have been given serious consideration for the death penalty. But we had some grainy video footage, some inconsistent statements, and one fraction of one sperm cell, where it was very difficult for us to prove a lot of what happened and what didn't happen as far as that encounter with our victim that night. The victim was left in a bathtub with flowing water, so we did not have a lot of physical evidence. The house had been wiped clean with bleach and things. As a prosecutor, in my experience, if you take a case and you file your motion to seek the death penalty, you are upping the ante across the board as far as how that case is going to be litigated, how your judge is going to look at that case, and how your jury is going to look at that case. I've taught a lot of capital punishment seminars around the country, and what they always refer to in capital murder cases is what's called super due process. We have due process in all of our cases, but if there is a possibility that this case could end in loss of human life by a lethal injection, you are going to have many more hurdles that you have to overcome. If you have close evidentiary issues, you should count on losing those. If you have a close call on a jury instruction, you should count on losing that because the judge is going to appeal-proof that case. If you have a case that's kind of a whodunit, or we're 99% sure we can prove whodunit, you should never, in my opinion, take a whodunit case and seek the death penalty. It's got to be, we absolutely know who did it beyond any doubt. We want this jury to look at what punishment is appropriate in this case. You don't want to take away your chance of obtaining justice on the regular homicide because you're seeking the capital punishment. So that was a factor I looked at in that case, despite how evil the person was in their prior history. I looked at what I had available to me to proceed on. I didn't try the case. Three of our other prosecutors tried that case and did a fantastic job with it. But I had concerns on evidentiary issues that we were going to lose if we sought the death penalty on that case. We had 404B evidence in that case that initially came in from a prior sexual assault with strangulation, which was very similar to what happened in the newest case. And initially that was coming in. I don't think the court would have given that any consideration had we been seeking the death penalty. I think it would have been a foregone conclusion and a non-starter. So all different things you have to think about in those cases. The capital murder case that we tried, when we initially sat down with the family, how many people have heard of James McVeigh? A couple of you. McVeigh in 2011, the first day he was released to transitional housing from the penitentiary, it was June 30th, 2011, went to Walmart in Sioux Falls, stole everything he needed to go on this mission to kill the President of the United States. He was a 7-time convicted felon, decided that he wanted to go on a killing spree, kill cops, steal their AR-15s, and then ultimately shoot the President on the golf course in Washington, D.C. McVeigh went from the penitentiary to Walmart, stopped at the Chili's, stole some more things from Target, went under a bridge at Sertoma and Oxbow, spent the night, tripped on alcohol and cold medicine, and then found Ms. Shine's apartment, 3101 Norley Place, and stabbed her 9 times and slit her throat as she screamed out in pain, and told us that he mocked her because she was a Christian, and mocked her about her religion, that how's your Savior going to save you now, patted her dog on the head, wiped his blood off on his victim, and stole her vehicle and took it across Madison, Wisconsin, where he was stopped. Law enforcement here locally discovered that Ms. Shine's vehicle had an OnStar device on it. They located McVeigh through that OnStar GPS coordinating system in that device, and he was stopped after a high-speed chase in Madison. After that, McVeigh was brought back to South Dakota. We litigated the case for 3 years. Initially, we met with the closest family members that we were aware of. They were in favor of considering the death penalty. I always consider the victim's input, but tell them I can't make you promises because I have a responsibility greater than just to you in this case. I have a responsibility to my community as far as public safety, and to do what I think is just in this case. After litigating the case for several years, we had a distant relative that came into the picture and actually approached defense counsel. Well, actually wanted to cut my budget for seeking the death penalty after we made that decision, and worked with defense counsel and wanted to testify in favor of the defense. So your family members aren't always going to agree on what the appropriate disposition of that case is, but you want to work with those family members, keep them informed, and as you move forward on those cases. Charging decisions based on prosecutorial merit, available defenses, and jury appeal. Yeah.
How do you balance family pain with intra-family violence?
Well, I think you look at how close the relationship is. If it's a immediate family member, distant family member, but not just the relationship, but also the dynamics of who do you feel is, an advocate for the victim in that family. Sometimes you have somebody that's a close family member that's actually working against you, and you want to know what are their motivations for being involved in this case? Are they truly out for the victim's best interest and to make that victim whole, or represent them, or do they have maybe another prerogative? So you kind of have to just weigh and use your gut in evaluating, why are they part of this process? Why are they working against you? Why are they working with you? Other questions? Yeah.
Do you have any type of system for family members that inject themselves into the investigation against somebody?
Absolutely. We're very fortunate in my jurisdiction. We have 3 victim witness assistants that from beginning to end are part of that process. They draft a letter initially telling what the court dates are and when the next appearance will be, what the bond is, the bond conditions, help them get a protection order if they need to, provide the resources to them in those cases. And they are kind of a conduit of information, and that information is brought to the assigned prosecutor. I think that's probably, I think their job is a lot more difficult than mine. If you look at a lot of the dynamics in domestic assault cases, classic case that we do hundreds of a year, a victim calls our office, talks to the victim witness assistant, says, hey, he's the sole breadwinner in our family. We've got 4 kids. He's in custody. He can't go to work. I can't do the house payment. I can't put groceries on the table. It's the first time it's happened. I know he'll get treatment. I'm comfortable it's not going to happen again. I want you to dismiss this case. I'm not going to come testify in court. Those are very challenging cases for us, and we really have very strong, all master's level victim witness assistants that provide that guidance, try to keep those victims part of the process, even if they don't agree with what we're doing, keep them informed, and they're just a real vital part of our team to keep the wheels on and moving forward. Yeah.
Did you work on the Connor Hansen trial? Did you think that the jury was aware that they could have convicted him of something less than first degree?
I do think that they were. I didn't try it personally. I was involved with the case from the beginning and made the initial charging decisions. The jury was properly instructed. I know one media outlet got that wrong initially and said that they were instructed that if they acquitted on the murder counts, that they had to acquit on the lesser manslaughter charges. The judge did not give any such instruction. I think the court gave an instruction on justifiable homicide. So if you feel that the homicide is justified, that would apply to all of the different charges, because if it would be unusual that if you're justified in homicide under a murder 2 charge theory, that you would not be justified in a first-degree manslaughter charging decision. So they were properly instructed. I can't tell you if they understood it or not. I suspect they did. There's also another instruction, just in my experience, that the court always says look at every charge independently and make an independent determination on that charge. I know they would have received that instruction. But that was a case where I was surprised by the verdict. I quite frankly thought they would probably compromise and end up with a manslaughter, maybe a heat of passion, or under this, we charge sub 4 in that case where you unnecessarily kill somebody even after they've committed a wrong or a felony against you. We had that as a charging alternative as well. Other questions? Yeah.
How many cases total in your career would you say you got to the point where you've approached the victim's family about considering the death penalty? And is it overwhelming where the victim's family members want the death penalty, or is it common to see them say, no, we don't want the death penalty?
It really varies. I've had several where it was a possibility. In South Dakota, Class A felony is punishable by either life without parole or death. But not all Class A felonies are death appropriate. We have separate criteria. I think there's 8 different criteria in South Dakota where the prosecutor has to prove one or more of those 8 criteria beyond a reasonable doubt that aggravating factor exists, in addition to the guilt, for the court or for the jury to consider the death penalty. In my years with numerous homicides, I've only filed once, and that was on McVeigh. Even after we brought him back, he threatened a guard at the penitentiary and told her, a female guard, that one of these days, one of you will make a mistake and you'll be gone. He had threatened and had thoughts of killing other people behind the walls of other penitentiaries. And we felt not only was that crime so heinous by itself, specifically how he murdered her and why he murdered her, and the great joy he took in murdering this 71-year-old hospice nurse, we felt that future dangerousness was a very serious consideration. If you look at other death cases in South Dakota with Burgett and Robert, those 2 essentially were lifers at the penitentiary and killed the guard. And that's a case where, there has to be another consequence available if people are at the penitentiary. They can't just have no checks or balances or accountability, because we have guards, inmates, and volunteers behind those walls. So future dangerousness is a big consideration in those cases. It certainly was in McVeigh, and he told us he would keep killing no matter what. He took such pleasure in it, just pure evil. So that was kind of a no-brainer. The family was supportive. We've had other cases where the family was opposed to the death penalty. We've had cases where we had a real mix. Some are just so distraught, they just want you to handle it and trust whatever your judgment is, and we try to walk them through that process. The problem is that you don't really get full closure even on if you get a verdict of death in a case. You've got years and years of appeals where the family sits in limbo, waiting for that process to be completed. So they're very emotionally draining. They're very difficult for everybody involved: the prosecutor, the defense attorney, the family, the judge, the jury. And that's the only case that I've ever written a letter to my jurors in a case and said, I can't believe what you all had to go through. Don't ever let anyone question your verdict. You were the only people that saw all the evidence and testimony in this case. I would have written you this letter no matter what your verdict was, because your service was impeccable, and we asked more of you than we should ever ask of any member of our community. It had several jurors that reached out to us and were very happy to decompress with us and tell us what they thought and appreciated our service as well. They're very fact and case specific as far as the death penalty, but I've only filed once in my life. Other questions? Go a little bit longer here and take a little bit of break. Defense is available. Rhett does a lot of DWI cases. Very common in a DWI case where a defense attorney will spot a suppression issue. Part of our exercise will be you're going to help draft a complaint and an indictment off a fact pattern on a DWI. My counterpart on the defense, Mr. Cheddar, I believe will have you consider a potential suppression issue. If I look at a case and I see a potential suppression issue where it's early on in the case, like there's not a reasonable suspicion for the stop, or the confession wasn't Mirandized at the custodial interrogation, and the officer didn't give a full and complete advising or no advising. That's something you want to consider early in your case, because you really have to, as a defense attorney, as a prosecutor, play defense attorney and look at every single weakness in your case and identify that very early on in the process. Evaluate your witnesses. Well, my star witness has 3 crimes of dishonesty, and I know the defense is just going to kill him for being a liar, and my whole case hinges on him. I think I might lose this suppression issue. Maybe I offer something early or up until a suppression hearing on this case, because I recognize that as a weakness. That's something that the defense can use as a bargaining chip, as leverage in those plea negotiations. So those are things you want to identify very early on. Indictments versus information, and I probably should also put grand jury versus preliminary hearing. Take a quick drink here. On felony cases in South Dakota, it used to be class 1 misdemeanors and higher, but any felony case in South Dakota, by statute, the defendant has a right to a probable cause determination. And there are 2 different ways to do that. The prosecutor can choose to take that case to a grand jury, where a grand jury consists of up to 10 members of the community. They can serve for up to 18 months, and it takes a quorum of 6 to vote in favor of an indictment on a case. That is a probable cause determination by those individuals, where they find that a crime was probably committed, and probably committed by this defendant as alleged by the prosecutor. We utilize the grand jury the vast majority of the time, and we do so for several reasons. One is, as far as congestion and convenience, we do not have time to do a preliminary hearing on every one of our cases. We had 2,600 felonies last year. A preliminary hearing on a felony would take an hour. I've had a preliminary hearing that lasted several days on a case. So with the volume we have, you go in and you present your main witnesses, establish your elements. Generally, the grand jury will find probable cause for an indictment. Another benefit beyond efficiency is that it's a different environment for your victim to come in and testify. At grand jury, the defendant is not present. The defense attorney is not present. There is not a judge present. It is the prosecutor and the grand jurors. In limited circumstances, a victim witness assistant can be in the proceedings for grand jury. But if I've got a 7-year-old rape victim and I'm going to be asking her about her dad violating her sexually, I'm going to do it in a grand jury in a private, closed proceeding where there's no media. The defendant's not staring at his daughter and re-victimizing her in front of the one that sexually abused her. It's going to be a much better environment for your victims to come in and testify in front of a grand jury, as opposed to a preliminary hearing, which is a hearing in front of a judge in open court with the defendant present in front of the victim witness in those cases. So there's really 2 benefits to the grand jury proceeding versus the preliminary hearing. I have had preliminary hearings on big cases for one important reason: to preserve testimony that's subject to cross-examination, the confrontation clause. I had a brutal tequila-fueled stabbing just a couple blocks north of my office on Minnesota Avenue in Sioux Falls, where I think everybody in the house, I think there were 15 people living in this 2-bedroom house, some up in the attic, tequila bottles everywhere, blood everywhere, beer bottles throughout the house. I was at the crime scene shortly after. It was just a horrible crime scene, and every one of our witnesses, including, I think we had 3 people that were stabbed and one of them fatal. I think the most sober person in our house was a 2-5, and generally all transient, didn't have any ties to the community. They were, I think, temporary seasonal workers. I could take that case to grand jury and get an indictment and then go to trial knowing that I'll probably never even find any of those people to drop a subpoena on. Or I can go through the tedious work of doing a 2-day preliminary hearing with 3 different interpreters in 3 different languages. And my former law partner, Tom Hensley, and I did a multi-day preliminary hearing on that case. And we had a videographer and a court reporter. And so we had everybody cross-examined by the defense attorney in that case to preserve that testimony. So if we had unavailable witnesses at a later hearing, that testimony might still be available to us. So those are, that's a very good reason to have a preliminary hearing. Also, I've had cases where I just wasn't sure about my witnesses and I wanted to give the defense attorney a good crack at them to see how they performed and see how they looked in court, to see if I believed them, or, you kick the tires and test out your case a little bit at the preliminary hearing and see what you really have instead of just, bringing in the basics and the elements at grand jury. So some of the differences between those two questions on grand jury versus preliminary hearing. Might be a good place to take a quick 10-minute break if you guys like. Grab some caffeine probably.
We're going to go ahead.
All right, everybody get some caffeine, I hope.
That was a good thing.
Oh, God, it's awful. It really is. This class is so much better.
All right, how do I get to the next? Oops.
Oh, I can do it from here.
Okay, there we go. All right. We talked about having discretion earlier. As the chief prosecutor for Minnehaha County, I'm the elected official. So technically I'm elected, and then all of my deputies are appointed by me and are expected to follow my philosophy and my policies. We talked about the county commission has control of my budget, but they don't have control of my charging decisions or philosophy. So I am really held accountable to my general public because they are the ones that elect me. Fortunately for me, when I ran in 2008, I was unopposed. My predecessor had been state's attorney for 20 years. I think he was unopposed except for his first term in his primary. I was in private practice, working a lot less hours and making a lot more money per hour than as a state's attorney, but my predecessor and several suggested I consider running for election and being the new elected state's attorney because I always enjoyed that type of work. As much as I enjoyed being a defense attorney and being an advocate and the hours and taking my boys to the zoo every Friday afternoon and not working as many hours or taking phone calls at night, to me the joy and the attraction of being a prosecutor is having that discretion and that ability to follow your heart and do what you think is right in any circumstance. As a defense attorney, I talked to you about the case with the mandatory minimum. You can be a great lawyer, but the prosecution has so much discretion that you really have to be very effective, because if you don't talk the prosecutor into considering some alternative for your client, you're very limited on what you're able to do. And I felt it was frustrating to me as a defense attorney not to have that power, not to have that discretion to help people. I could be an effective advocate, but at the end of the day, it's the prosecutor that makes the charging decisions, decides if it's going to be a deferred prosecution or if he's going to make a sentencing recommendation of this or that, or consider some specialty court as a gatekeeper into the drug court or DWI court or veterans court. But with that power, kind of like, I think, is it Spider-Man, with great power comes great responsibility? Am I quoting the right movie? It is an incredible amount of responsibility, and you are accountable to your elected people. I was unopposed. I like to tell people that I was such a qualified candidate and such a great prosecutor and lawyer that everybody else was scared to run against me, but in reality, I think it's just such a difficult job that nobody else in the county really wanted it. So that's why I kind of won by default, and I was unopposed the next time as well. But you always have to remember who you work for. You work for every member of that community in that county. You are held accountable through the voting process, but also through the media. The media doesn't always report things accurately, but there is a lot of publicity involved with that job, and you do have to answer for all of those decisions. What I always tell the prosecutors in the office is follow your gut. We're not there to make the popular decision. We're not there to be everybody's friend. We're not there to do anything political. I don't involve myself politically, even though it's a partisan election. But we're there to always do what we think is right. And I tell our prosecutors, I would rather we lose every single time playing by the rules and doing it right than ever win by cutting any corners. So that's what I expect of all of our prosecutors. And you have to have, beyond your own internal, you have to have your internal standards beyond what the special rules are that we need to follow as prosecutors. We have 2 rules that are really specific to us. And when I interview young lawyers applying in our office, I always share with them my philosophy of being a prosecutor. And it's most effectively, I think, mirrored in the first sentence of the first comment in Rule 3.8. It says the prosecutor has a responsibility of a minister of justice and not simply that of an advocate. And I truly believe that's what our mission is as prosecutors. We're not there to be heavy on crime and get maximum sentences on every case. We are there to be seeking justice in every single case. We talked a little bit about the paradigm shift in juvenile justice and adult corrections and how we look at cases and how we look at incarceration. There's been a similar paradigm shift in just the handling of cases where I don't expect our folks to be just merely case processors. I really expect them to be community problem solvers. So when we see problems in our community, we need to meet those problems by sometimes getting creative. I was the senior felony drug prosecutor from 2003 to 2006 and always had 150 meth cases, did a lot of the meth distribution and meth lab cases back in the day. And I always told myself that I had a good day at the office when I sent 3 people to the penitentiary or would high five somebody because somebody went to the pen, because that was success for me back in those days. For me now, looking through a new lens, getting a lengthy penitentiary sentence is not always success. Sometimes success is reuniting an addicted mother with her children, or providing the resources to somebody to fight their addiction and pay taxes and have proper employment and sober housing and equipping people in our society to succeed that pretty much never had a chance previously. So we take those responsibilities seriously. We have the special rules that we must follow, but we expect more out of ourselves than just the specific responsibilities. Rule 3.6 really is publicity, and that's a tough one for me. There's a lot of things that I want to tell the media about our defendants and about our cases and our facts and how bad somebody is, but I can't. I'm really limited under Rule 3.6. I can say what the charges are, the next court date, the agencies involved, really just about it, what the penalties are for that offense. I can say things that are a matter of public record, but I try to limit myself. A lot of times in our bigger cases, law enforcement will draft what's called an affidavit in support of an arrest warrant, which really sets out all of the facts that we have. We provide that affidavit to a judge. If the judge finds probable cause, they will file our criminal complaint on those charges and issue a warrant for the defendant's arrest. Those are very helpful to me as a prosecutor because I can tell the media there's an affidavit in the file that lays out the facts that we are alleging. Go look at that. So it's not coming from me, so that on the news it's not Aaron McGowan said this, this, and this. We pulled the affidavit. It's different if they read the affidavit than it's, the state's attorney said that this guy did this and this and this. So I really try to insulate myself. The easiest thing I could do would be to go on TV or talk to the media and say everything I want about a defendant, but I can't. I can't really until the case is disposed of. Post-sentencing, I can pretty much say what I want about the case and, you know, the evidence and the defendant and whether it was an appropriate sentence and the unique facts and circumstances. But I just can't go on and talk about somebody's criminal record or the facts or circumstances, because I'm really poisoning my jury pool. Because there's a chance that one of those people that watched that media on that night could be drawn in as a potential juror in that case. And they're going to be eliminated as a juror if they heard me, you know, go off and make some public comment. It's just not appropriate. So it's very difficult. I see prosecutors nationally that make that mistake daily. I saw the other day, I about fell out of my chair. I was reading the paper and there was a prosecutor somewhere south where a defendant escaped, and this prosecutor referred to him as Hannibal Lecter. Said they just let Hannibal Lecter out. That's, I mean, a prosecutor can't say that because this guy's going to face an escape charge. And here the prosecutor, the chief deputy prosecutor, is calling this guy Hannibal Lecter. You can't do that. I saw in the case years ago with I think it was the Duke lacrosse team, where the prosecutor went in and got in front of the media and started bad-mouthing all these kids on this team with very little evidence, and was way outside the scope of Rule 3.6 in those allegations. So it's very frustrating when I see that somebody goes out of bounds on that, because we're very limited by what we can say. I point the media to those rules all the time. I said, I'm precluded by this rule. I can't tell you more than that. I'd like to. You're going to have to get it from somebody else. You're free to go to the court hearing. Anything I say in court is fair game for you. Obviously not in a juvenile proceeding, but they are in the adult criminal cases. The importance of being able to say no to those seeking to take advantage of your office. Early on, one of the real challenges of being a new prosecutor after my predecessor of 20 years, who's just an incredible lawyer and prosecutor, and was a great boss. There was a lot of prosecutor shopping. I had a lot of frustrated members of law enforcement or from the community that maybe didn't agree with the decision made by my predecessor in choosing not to file charges. And they thought, oh, here we've got the new kid in town, he's 34 years old, we're going to take a run at him and convince him to take another look at this case, and talk to him about all the terrific evidence we have and all the merits of prosecuting this case. I had people from cases that were ruled obvious suicides that you want to believe the best in your family and your loved ones, that wanted my predecessor to take a look at a homicide charge out of what was determined to be a suicide by the coroner and law enforcement. Old theft cases, old property crimes. Everybody wanted to take a run at me. It's difficult to say no. Sometimes these are close colleagues, attorneys. Some may have even supported you in a campaign or otherwise. You have to remember that discretion can only be used appropriate, and you never want to risk your reputation by doing a favor or doing something stupid. I can tell you, in my experience, it's a very small bar in South Dakota, and if you plan on living in a place with a small bar, your reputation and your character are everything. Once you can spend a lifetime building up that character and reputation. It takes one stupid move to lose it, or lose the trust of everybody that you work with. I've had a defense attorney misrepresent a plea agreement to me or a judge that I will never trust again on any case. It just takes one stupid thing, and you have to remember that as a prosecutor as well, that you have that discretion, but you have to use it appropriately. If you abuse it, if you do a favor, something stupid, your community's not going to trust you, the bar is not going to trust you, the judges aren't going to trust you. There is incredible pressure from law enforcement. I had a homicide case that law enforcement built up to me, came in with the police chief and all of the command staff and the captains and the Crimes Against Persons unit, and wanted me to take a look at it. My criminal chief and I evaluated it, and at that time we didn't feel it was proper to bring charges. I felt we had too many problems with that case, and once we call a jury, jeopardy attaches, and then I'm probably going to lose that case, and I'll never have any more evidence to prosecute it, and we're done. So you have to make those difficult decisions. You have to stand up not only for justice, but yourself and the office and the truth, and your ability to seek and obtain justice. You get a lot of victim pressure. You get a lot of the cases where the victims don't want you to do anything, aren't able or willing to stand up and protect themselves, and don't want you to do so either. We have other victims that want you to go out and seek the death penalty and have the offender diet by lethal injection. So you have to be able to withstand those pressures, explain your rationale and your reasoning in a reasonable manner to them. A lot of times they'll come around and understand why you're taking the position and why you can't jeopardize this case by doing something in a certain fashion. Tons of media pressure and public pressure. You know, when we had McVeigh, it was obvious from the beginning that that was a case where the death penalty would be considered. I waited months and months to make that determination, and when I teach classes on capital punishment, I always encourage and suggest others do the same, because you want to hunt down, find every little piece of evidence. You want to know everything about your case in advance, and your defendant, your victims, your witnesses, and your evidence. We knew in that case that there would be an issue as far as the defendant's mental health, his sanity, his competence, because of some statements he had made. I waited until the defense team got their own expert forensic psychologist, psychiatrist to do an evaluation of their own client. So it was their own expert that did the evaluation that determined that he was sane, that he was competent and bright and articulate, had some guarded diagnosis of mental illness, but because of an incomplete history, because of a lot of deception by the defendant, there wasn't a real solid diagnosis. But we waited to have that. As a prosecutor, if I crumbled to the media pressure to make a decision on the death penalty, because they called me every single day to ask me, hey, Aaron, are you going to seek the death penalty on this guy? If I pull the trigger early on that case and it comes back the guy's not sane or competent, I mean, how bad do I look as a prosecutor making a decision on the death penalty before I even know if our defendant's sane or knew the wrongfulness of his actions? So you have to be very mindful of the media and take your time, make sound decisions, because these decisions have incredible impact on other people's lives and liberty, and you can't just rush to judgment to appease the media, to get your name in a headline, or to get somebody off your back. You do get pressure from fellow lawyers. A lot of times you'll have civil disputes where you have attorneys on one side where one wants all the police reports or somebody's background check or rap sheet, or divorce cases. A lot of our traffic accidents or vehicular homicides are going to have a wrongful death suit as part of it, and you can get pressure from other attorneys in other realms in the civil realm wanting you to take particular action because it helps their case, or they want you to get a guilty plea to the careless driving offense because it helps them in civil court get a bigger property damage settlement. So you have to be mindful of that. Speeding tickets. The best thing I ever did as a prosecutor was I was running late. I was a groomsman in one of my best friend's weddings, and the store shorted us on some cufflinks for one of our tuxes, and we were afraid of his bride-to-be, and we were afraid to be late for the rehearsal dinner and the pictures before the wedding. So I was speeding down to get back to the place, to get the cufflinks, to get on time, to get our pictures taken, to avoid the wrath of my buddy's soon-to-be bride. And I got pulled over. I was a young prosecutor. It was a daytime officer. I did almost exclusively DWIs at that time. Didn't recognize me or my name and gave me the speeding ticket. I paid it the very next day I told my boss, and paid it the very next day. One of the most valuable things I have in my office is a speeding ticket. So when my friends or college buddies or law school buddies or somebody from the community calls me up and says, hey, McGowan, I got the speeding ticket. What can you do for me? I paid mine, you pay yours. So an invaluable tool in the prosecutor's office. I'm not telling you to get a speeding ticket, but if you have one, it can be a very useful tool. I tell people, especially somebody that's high profile that asks me to fix a ticket, I say, if I fix your stupid ticket to save you $150, you know what's going to happen? I'm going to be on the cover of the Argus Leader, and you're going to be on the cover of the Argus Leader, and we're both going to look incredibly stupid. So pay your $150. So my 2 cents worth on fixing tickets. I've never fixed a speeding ticket as a prosecutor, and I never intend on doing so. Prosecutor shopping, we touched on that just a little bit. It happens. Different prosecutors, despite policy and my philosophy, have their own values and philosophy on different types of cases. There's not always 100% cookie cutter cases and consistency across the board. Discovery, and it's really, I think it's really kind of a non-issue for us because we just supply everything right away. We have an open file policy. We have one staff member that is completely committed to just copying electronic discovery, another one that does the DWIs, but we generally require it doesn't have to be a formal motion, but a written letter requesting discovery, which triggers reciprocal discovery under the rules in the event we want to seek reciprocal discovery as far as experts and things of that nature. I always tell our folks, err on the side of caution. If you have it, turn it over. There's really nothing we will ever have that will not be shared with the defense. I want them to have everything. I want every case to be appeal-proof. I don't want us to ever be questioned on things. It does get sticky with things outside of our control. Last year, I think we copied 40,000 different videos as far as electronic discovery from our police department, highway patrol, sheriff's office, other local law enforcement. The clock is ticking on a lot of those different types of media, like an officer's arrest video or an interview video. They have an automatic timeline on them. I think like 6 months they fall off the server. So if an officer forgets and doesn't download that into the system, we can lose those. Those are issues that are difficult for us on a Brady motion, that we destroyed evidence. In those cases, we don't always have control of all of it. Sometimes we have cold cases. Sometimes we have cases that are out on warrant longer than 6 months because the defendant failed to appear to an initial appearance, so the case just kind of goes dormant until they're arrested on the warrant. Yeah.
So the police officer was involved in the shooting with the body camera, put that in their locker, would you do the warrant to get that?
The way we do it is after the shift, every officer, no matter what, is supposed to, well, if they have an arrest, they're supposed to download that into the system automatically, which I have 3 different investigators, and a lot of what they do are pull the officers' videos out of that system to reproduce for defense counsel. The Sioux Falls Police Department has what's called an arbitrator system. So they've got a camera that goes out from the patrol car, but they also have a camera that goes to the back seat. So if somebody is in custody, we have everything that happens in front of the squad car and inside the squad car. And we have internal mics picking up the audio, as well as the officer's body mic out in the field or in a house responding that records. And I think the way the cars are set up, the officer can trigger it automatically. Otherwise, anytime the officer turns on his overhead lights, that triggers the camera system. Does it go back 30 seconds? It does. So automatically, as soon as the officer turns on their overhead lights, the recorder goes back to the previous 30 seconds, which is helpful on a stop for DWI when there's weaving or somebody runs something. You know, we can go back and capture even before we initiated the traffic stop on those cases. So we have those systems. We are testing body mics on our motorcycles and bicycle officers. We have several motorcycle and bicycle patrols. So that'll be part of the process. They are really responsible for getting everything that they have into evidence and downloaded after their shift. It's all available to me without any subpoena power or anything. Just as a member of law enforcement, we get all of that automatically. We share their system, so I have access to all of their reports that they type up immediately. We get those in real time as soon as they're brought in. So we get all of that, and then as soon as we get a letter from defense counsel or find out who defense counsel is, we provide all of that. So our investigators do that. They also have to edit all of those videos. Like if we have a DWI stop and the officer calls in during or after the arrest and wants to know what their driver's history is, and dispatch says, well, he's got 2 prior DWI offenses, he's revoked by statute, no driver's license. I can't play that in front of a jury because it's too prejudicial. I can't tell the jury the guy's got 2 prior DWIs. We have to go in and edit all of that stuff out that we know based on the rules of evidence. It's not appropriate for to bring that information in. So we have to do a ton of editing. And once we move over to body mics, I'm going to need about another 10 staff members. We had an incident where I think 25 officers responded. We actually had 3 officers that were down in an incident where there was a meth-fueled assault where our defendant assaulted his mother and his sister with a landscaping brick. The initial officers that responded, he knocked one down with a roundhouse punch, broke another officer's socket and put another one on the ground with his arm was displaced somehow. So we had 3 officers down simultaneously. You can imagine the response at that time. I was listening to it on my police radio. Massive response because it was just a very intense scene where we needed numerous officers. I think it took 9 of them to take this guy down that was on meth, real big, strong guy, completely out of control. So if you have 20 officers responding and I've got 20 body mics going simultaneously, plus every squad car with a front and back camera, 2 things. That's an incredible responsibility for my staff to provide as discovery and edit. Also, the cost to the county to provide that much space for all of those different types of media to be stored for whatever period of time it's a very expensive notion for our office staff to do all of that. Other questions? Doing okay on time here. We talked a little bit about reciprocal discovery. A lot of times we'll do a notice of demand of alibi. The statute says that the defense has to respond within 10 days, but realistically, they're not going to be held to that 10-day response. Part of your assignment will be to do a criminal complaint, and then in the indictment, at the end of the indictment, there's a demand for notice of alibi information. There's a template for you, so I'll have you look at that. But if the defense attorney files a notice of alibi 15 days after the request, it's not like it's not going to come in, because then it's going to be a issue on habeas for ineffective assistance of counsel. So it's not a real rigid 10 days. It's just kind of a goal. We also have our judges have, in addition to statutes, regarding discovery, we have our own local rules as far as providing initial discovery and then supplemental discovery. Most DWI cases, you're going to have an arrest report and some field sobriety tests, which are going to be done very early in the process. I have homicide cases where you have evidence coming in and DNA and supplemental reports and new witness statements coming in for months afterwards. So we just turn it over as soon as we get it. But you have to, if you want to look at your local jurisdiction on what their rules and requirements are, because there may be some in addition to what your statute set out. Discovery continued. Not only discovery to your defense counsel, which obviously is required, you want to be helpful to your judge. If you've got something the judge needs to see in advance to make a decision on, a classic case would be a sentencing. If I show up at a sentencing hearing and I've got a booklet full of letters from my victim's family or something else I want the judge to consider, and then have that judge be forced to sit there and read it in a full courtroom while we're all waiting and watching and putting them behind for an hour for the next hearing, don't do that to your judge. They're not going to be very happy with you for doing that. Provide it in advance. If you've got a motion or anything else you want to see your court to see, don't ambush them. Do it before trial so they can have an evidentiary hearing on it, so they can be provided with the motion and the law and the supporting materials. Oftentimes our judges want to see the video of the stop. If there's a suppression issue, provide that in advance so that they can do that on their own time when it's convenient and not be stuck doing it in court. There's a lot of things you can do during the trial, but if it's going to take any time at all, it's such a hassle, and your poor jury has to go sit in the jury deliberation room while you guys fight it out on something you should have done pre-trial. So do it in a timely manner. Make sure you get your judge everything that they need to have to make an informed decision, and do that in a timely fashion. Plea bargaining. Any questions right now? Like we talked about earlier, plea bargaining is very difficult. It's something that I always tell our newer and younger prosecutors at the onset. You know, you really set the tone and your reputation early in your career. If you send out an offer, and how many cases did you have in your trial calendar last week? 70? 74. If Rep By sends out an offer on his 74 cases on his trial calendar, and then 5 days before trial, there's a huge fire sale, and he cuts every offer in half and says, well, I'll give you this now, I'll give you this now, because I'm busy, I don't want to go to trial, so I'll give you this, or I'll give you that. And if you have a fire sale every time your feet are to the fire and on your jury trial dates and sell your cases short, you're going to have a horrible reputation as a prosecutor that all I have to do is wait till the last second that I know I'm always going to get this deal or that deal, and the offer always gets better with this prosecutor. Stick to your guns. If you're a new prosecutor, make that best offer the earliest offer. Say, hey, this is as good as it's going to get based on my evaluation of this case. Some cases are fluid. Maybe you lose a witness, something changes in your case which justifies changing your offer. But generally speaking, the best offer should be your first offer. You're generally not going to have a worse offer down the road. It might improve a little bit, but stick to that offer. And then if they don't accept that offer, take that case to trial. If there's prosecutorial merit, if that case warrants a jury trial, take it to trial. I'd rather have us try cases and lose them and try them for the right reasons to show that we're able and willing to try our cases instead of having a fire sale. And that's huge on your reputation as an attorney, because if early in your career you stick to your guns and show them that you're not afraid to go to trial in these cases, they know when push comes to shove, they're going to have to make a decision and tell their client, hey, this is Rep By. I know that this is as good as it's going to get, and here we are. You need to make a decision, and this is what we need to do on this case. It's invaluable to you as a prosecutor. Dealing with victims again during plea negotiations, we touched on it before. They're not going to agree with you, a lot of the time, but as long as you're fair with them and upfront and honest, and keep them informed of what's happening, even if they don't agree, they're gonna be with you the vast majority of the time. Always tell them that I can't make any promises. I'm going to invite your input. This case is important to both of us. I need to know what your thoughts are, but at the end of the day, I have to use my experience and my skills, and I know this judge. I know what we can get on this case, what's reasonable based on my training and experience, and explain to them why you're proceeding in the fashion you are. Victims' rights statutes, and I think there's 15 different requirements under this 23A 28C1. We have to notify victims of everything from the court dates, input on plea bargaining, parole release dates, and things of that nature. And in my office, those are generally the tasks of those victim witness assistants. The attorneys share in that responsibility. It's a huge responsibility, and our victim witness assistants have huge caseloads, just like our attorneys, and incredible responsibilities. Some victims require a lot of time and a lot of attention. We will have a victim witness assistant accompany them to grand jury, sit with them through a several-week jury trial, sit out in the hallway with them when they are in a time of need, provide resources, get them to the children's end, tell them where to get a protection order. We have a lot of responsibilities to our victims in our cases, and those are set out by that statute. Like we said, it's an elected partisan position, but in my experience, a prosecutor should never be a politician. They should always just be a prosecutor first. Don't get involved with hot button social issues. Your job is to enforce the laws on the books and do so fairly and justly. Don't get involved with a bunch of political issues that are going to hurt the office or hurt your reputation or your office's reputation. Occasionally, you're going to have a conflict. There's, with open meeting laws, occasionally there's a county commission that will violate those laws under 125.6. At least you have the 125.6.1 where you can refer those cases to the Attorney General. We have concurrent jurisdiction with the Attorney General. The Attorney General has concurrent jurisdiction statewide. If I have a conflict on the case, I can call my friend Marty Jackley and say, hey, Marty, we've got this victim. of this homicide. Now this victim's charged with drug distribution. Can you take that drug distribution case, because I don't want to prosecute my victim for drug distribution when they're a victim in a homicide case. That's kind of a conflict for me and not very comfortable for any of us. You might occasionally have a staff member that has a family member in trouble. If it's a close call, it doesn't have to be according to the rules. If it just doesn't pass a smell test, give the case to somebody else, because if there's an appearance of impropriety, you don't want to put yourself or your office in that position. Just always follow your gut on those. Different types of prosecutors. When I'm hiring, I really want the committed prosecutor that is dedicated to the cause and seeking justice. The good prosecutors, they go on the ride-alongs, they know all the police officers' names, they go to the homicide scenes, they get whatever training they can, they're quick to volunteer with their colleagues, get involved with the association and do lobbying. Some folks, you have to kind of weed them out, just want a couple of years of jury trial experience and then want to just go make money in the private sector or do something else. But when you kind of have to decide real early on, am I committed to this for a career, or is this a stepping stone for me? Opportunities. There's a lot of great things about being a prosecutor. You get to have a significant impact on the community that you are living in or raising a family in, setting policy, procedure, enforcing laws, standing up for vulnerable victims. There's nothing more rewarding than having a child victim that's gone through the most horrific thing they ever will and bringing justice to that young girl or young boy, or anyone that's been a victim of a serious or violent crime, and standing up for them and obtaining justice, and so holding somebody accountable for that evil act. There's nothing more rewarding in the world. But there is a lot of discretion, and we talked about that. You have to use that appropriately. I've had a lot of opportunities. I'm the current president of the South Dakota State's Attorneys Association. In that, I get to be involved with a lot of things on the state level. I've drafted legislation. I've been to peer and testified in the House and Senate in front of numerous committees. I've been on the Chief Justice's Committee on Interpreters and Translators in the Courtroom. I was on the Governor's Work Group for Senate Bill 73. I'm the Attorney General's appointee to the Public Safety Improvement Act Oversight Committee. I'm on the Chief Justice's Drug Court Advisory Council. We've been able to establish a drug court, a DWI court, and a veterans court in my office that we never had previously. I've gotten to go to Washington and meet with like-minded folks. I have great friends in law enforcement that we socialize with, and really have a great working relationship with our detectives and our patrol and command staff. It's a very important part of that job. They need to know that you've got their back when they get assaulted or somebody questions how they did it. As long as they did it right, you're obligated to back them up on it. And those are very important relationships as a prosecutor. I think that we've been very progressive in our office, and we've looked at things with a new lens to be smart on crime. You can be very popular as a prosecutor, always being tough on crime, but you have to find that balance to be smart on crime. You have to have empathy and compassion and look at the individuals, not just the offense. You want to look at the full picture, and you need to understand that individual and their past, and is there an ability to rehabilitate? What other things can we do short of incarceration that are more cost effective for our taxpayers in these cases? What's difficult about being a prosecutor, I think it's as rewarding as it is. I think it's equally probably emotionally draining. I don't know how many homicide scenes I've been to. I don't know how many autopsies I've been to. I remember the first child autopsy I went to. Some of those I go to because I need to make a charging decision early on. And if I've got a 2-year-old child that has multiple skull fractures, and I've got a suspect telling us that the child fell off a mattress 2 feet and there was one impact, and I'm at the autopsy and the coroner shows me 3 different impact points on 3 different planes and subdural retinal hemorrhaging and hematomas and things of that nature. I know once I have 3 impact points and a suspect telling me he fell once and hit his head on a surface like this, or if I have a jagged, curved skull fracture, tells me it was a curved or pointed point of impact. Those are important things I need to know to make a charging decision early on, because if this person killed an infant, this person needs to be arrested immediately. If we're not sure, I need to hold off and have more investigations. But those things are emotionally draining, because you're talking about a human life that has ended, or a child in those cases. So, I've also witnessed an execution. I'm one of a handful of prosecutors that's been a witness to an execution. I was a witness to the Eric Robert execution at the penitentiary. I'm one of a few prosecutors that's handled a death penalty case from start to finish, and we were in trial for 5 weeks, and I think I worked 18 hours a day for 5 weeks straight. I got phone calls throughout the night and answered probably some 300 emails a day to stay on top of everything. But despite all the challenges and the drain, it's an extremely rewarding career. And also, we get badges. How cool is that? With that, I would encourage you, if you have not looked at criminal law, to consider doing so. If you haven't, I would ask you to consider being a prosecutor. There's no better way to be a lawyer and have great trial experience, and it's interesting every day. Every day, it's amazing what it takes to shock me these days, but I still get shocked on occasion, and it's always interesting. But I do encourage people to be defense attorneys as well, and I really enjoyed being one. The process only works when we all do our job correctly. It starts with the officers following the rules and only stopping people for the right reason and following the book every single time. The process only works when we have effective defense attorneys that are strong advocates, that fight the good fight, stick up for the Constitution, do everything in their power to zealously defend their client. If we have a defense attorney that thinks their client's guilty and just punts it, we all lose in the system. I always want the best attorney on the other side to ensure that defendant's rights are being appropriately addressed and that we're following the Constitution. And I want to appeal-proof that case. I don't want to try it again because somebody messed up and did something wrong. And the process works when we have judges that rule appropriately on rules of evidence and impose appropriate sentences when necessary. So it's a fascinating world that we work in, but I would encourage you to consider it if you haven't already. So with that, I'll answer questions. Then do you want me to kind of cover the work or do we want to just do that tomorrow on the phone call for the assignment? Okay. Questions? Anything you ever wanted to ask a prosecutor?
They'll get to ask questions tomorrow
Yeah.
as well. So I just think we're so fortunate to have been present for this presentation. I mean, so much valuable information and all your experiences. We really thank you for the time you've taken out of, it's a very busy schedule. So
My pleasure.